Good morning and welcome to Law Talks here on 4CRB. Well, living in a unit, townhouse or over 50s lifestyle community can be a fantastic way to enjoy a low maintenance lifestyle, and there are plenty of options on the Gold Coast. But it can also come with its fair share of challenges, especially when it comes to dealing with body corporate committees, bylaws and neighbour disputes. From disputes over common areas to getting renovations approved, these issues can quickly escalate if people don't understand their rights and obligations. To help us better understand body corporate and some of the issues that many people face, we're joined by commercial litigation lawyer James Griffin from Attwood Marshall Lawyers. Good morning, James.
Good morning.
Well, James, for people living in units or considering downsizing into a complex, what role does the body corporate really play in their day-to-day life?
So I guess the best place to start would be what a body corporate is. A body corporate is created when land is subdivided to create what's called a community title scheme. When a community title scheme is created, all owners within the scheme are automatically members of the body corporate when they buy their lots. The body corporate has three main responsibilities. They are maintaining and controlling body corporate assets and body corporate common property. So, for example, gardens, foyers, stairs and other shared facilities. They also have a responsibility to maintain and enforce the bylaws and to undertake what's called levy collection. So that's the collection of funds from lot owners, which are then used and applied for maintenance, insurance and the operation of shared facilities.
Okay. And James, a lot of people feel frustrated dealing with their committees. What power does a body corporate committee actually have, and where are the limits?
So a body corporate committee is essentially a small group of lot owners who are elected at a general meeting just to manage the everyday affairs of the scheme. So that's the things like maintenance and repair to common property, enforcement of bylaws, engagement of contractors, and it can also approve certain expenses. But there are some limits on what a committee can do. So for example, if a body corporate's looking to approve a large expense, depending on the size of the scheme, they may be outside their spending limit. And in that instance, they would need to go to a vote of all owners at a general meeting.
Okay.
In Queensland, the powers of a committee can vary depending on the regulation module that applies. So what that means is, for example, the committee of a body corporate for a commercial lot has different powers to the committee of a lot for example, holiday short-term letting. But generally, the committee have a statutory duty under the Body Corporate Community and Management Act to act reasonably in any decisions that they're making. So there are checks and balances in place.
Yeah, okay. And we often hear about bylaws, but what are they in practical terms and how do they affect everyday living?
It's a great question. So a great way to think about this is that laws, like laws of the land, are codified by Parliament and apply to everyone in a state. Bylaws are a set of rules that are created for that particular building or complex. Generally, bylaws are made to deal with issues concerning the common property, any body corporate assets, any services or facilities that a body corporate provides, and the use of individual lots within the scheme. While every scheme is different, they generally cover things like the keeping of animals, visitor parking, noise and renovations to lots.
Okay. And what are some of the most common bylaw issues you see causing tensions between neighbours or within complexes?
There are a few common bylaws which we see cause tensions in schemes. They're primarily parking disputes, so issues around people overstaying their welcome in visitor car parking, noise complaints, so that might be lot owners have friends over frequently late at night, or we see some instances where they're vacuuming late at night, that sort of thing. Another big one is pets. So the Body Corporate and Community Management Act has recently been amended so that the body corporate can't unreasonably withhold consent to the keeping of animals. But prior to that, certain body corporates had really onerous bylaws which they tried to use to regulate the keeping of animals. So they imposed criteria like you could not keep an animal if it was over 10 kilos, or you could not have more than one animal. That's changed a little bit, but that was definitely a major source of tension.
And if someone breaches a bylaw, what actually happens? Is there a formal process before it escalates?
Yeah, so every state's a little different. In Queensland, generally, where a lot owners breached a bylaw, the body corporate will issue what's called a bylaw contravention notice. There are two types of contravention notices that can be issued. One for future contraventions, so that's where a lot owners previously breached a bylaw and they're likely to repeat that contravention. And the other one is continuing contravention, so the breach is ongoing or concurrent. The lot owner in that instance will have an opportunity to remedy the breach, and if they don't, then the body corporate may seek to escalate the dispute, and that's usually in the Magistrates Court or the Body Corporate Commissioner's Office.
And James, we often hear complaints about rising body corporate fees or special levies, or situations where people are paying those fees but things like lifts or pools or common areas aren't being maintained properly. What rights do owners actually have in those situations?
So they have a number of rights. Generally, our recommendation is always to take it up with the Body Corporate Committee at first instance. If the Body Corporate Committee aren't forthcoming or they're still having that pushback, they can generally seek to raise a motion for all lot owners at a general meeting, whether that's an extraordinary general meeting or just your yearly AGM. If after all of that you're unsuccessful, the dispute can't be resolved, you can look to make an application to the Commissioner's Office and they have the authority to deal with it, whether that's adjudication or conciliation.
And we hear people say they feel ignored or even unfairly targeted by their committees, whether it's a complaint not being answered or rules being applied inconsistently. What can someone do in that situation?
So my first piece of advice is always to have a written communication or a written paper trail of your interactions with the committee. That just preserves any sort of rights that you might have if you want to progress the dispute or it needs to escalate. You might seek to liaise with them at a committee meeting level or at a general meeting. But again, if that's unsuccessful, that looks like an application to the Body Corporate Commissioner's Office.
And if a dispute can't be resolved internally, where can people turn?
So, as I just discussed, they can turn to the Body Corporate Commissioner's Office. There's two options there. They are conciliation or adjudication. I'll explain what the difference is. A conciliation is more of an informal process. So that might be where there's no lawyers involved and where you just want to have an informal mediation. Adjudication is a more formal process, and that looks like an adjudicator being appointed who will publish some sort of decision or authoritative ruling on that dispute.
And for people who might be reluctant to take it further, is this process expensive or complicated, or are there simpler ways to resolve disputes first?
I think the first point of call, as I said, is to always speak to the committee and seek to resolve it at a committee level. Unfortunately, as these disputes escalate, they do become more costly. We see those costs usually lie in the steadfastness of a committee in dealing with these issues or not dealing with these issues. In those sort of circumstances, then yes, it can be costly. So it really depends upon the appetite of the committee to resolve the dispute.
Now, James, before buying into a unit complex, what's one legal or practical check people often overlook that could save them a lot of trouble later?
Reviewing body corporate records, without a doubt. The reason for that is twofold. Firstly, to review them in relation to any financial trouble that the body corporate might be in. For example, it may be a very large scheme, but they have no money in their sinking or administrative fund. That might be a red flag or a concern because you might question where are those funds going and why do they not have any money. The other reason is that you might want to consider the historical records of the scheme about difficulties with lot owners. Have they raised any special levies in the past? You might have undertaken an inspection of the property and the balustrades might look like they've become dilapidated. You might look to see whether they've been replaced in the past, or you might anticipate that another special levy will be forthcoming and you might be up for the expense of that.
Well, James, some really practical insights there and a good reminder that while community living can be a great lifestyle choice, it does come with shared responsibilities and rules. A big thank you to James Griffin from Attwood Marshall Lawyers for helping us navigate the complexities of body corporate issues today. Thanks for joining us, James.
Thanks for having me.
You've been listening to Law Talks here on 4CRB, which you can hear every Friday morning from 9 o'clock.